Prosecutor say something?
No. Sorry, just another question. Assistant Public Defender Chelsea Vergils with and on behalf of Montel Gatlin. Please state your name.
My name is Montel Gatlin. Thank you.
Before we even get into the legal mechanics of this hearing, pause for a second and recognize what kind of courtroom energy we're walking into here. This is not a calm procedural appearance. This is a defendant who already feels unheard, defensive, and suspicious of the system around him. Those first few seconds matter because they set the tone for everything that follows. We're dealing with Montel Gatlin, represented by Assistant Public Defender Chelsea Vergils, standing in front of Judge Simpson. 2 cases, incomplete discovery, a ticking statutory clock, and a defendant who immediately signals distrust toward his own attorney. This is where courtroom reality clashes with expectation. Many defendants come into court believing their lawyer should simply do whatever they ask. But public defense doesn't work that way. Lawyers have ethical duties, legal constraints, and strategic responsibilities that often involve telling clients things they don't want to hear. That tension explodes quickly in this hearing. You'll see a defendant who believes his rights are being waived against his will, a judge who has zero patience for legal misinformation, and a system that does not allow you to fire your lawyer just because you're frustrated. As this unfolds, pay attention to how Judge Simpson controls the room. He doesn't raise his voice, he doesn't insult, but he also doesn't entertain nonsense. This case will move fast, get uncomfortable, and expose some harsh truths about how the criminal process actually works versus how defendants think it works. And once bond arguments enter the picture, the stakes rise dramatically. Because now we're talking about freedom, safety, and alleged crimes involving a child. So the real question for you watching is this. When a defendant feels railroaded by the system, is that always injustice, or sometimes a refusal to accept reality?
What are we doing?
Your Honor, we are asking to set the preliminary exam in both of these cases. We do not have discovery in one case. I informed my client of that. He does not wish to waive the 21-day timeline in these cases. He asks to set preliminary exam regardless of knowing we don't have discovery on one case.
Which, yeah.
I mean, may I speak?
If you want.
I don't want her to represent me.
Okay, so you don't get that choice necessarily, but why?
Because just conflict, like we had a back and forth back there in the back room. Like, I don't think she has my best interest.
Really?
Yes.
Why? Because she wouldn't do it you?
Huh?
Because why do you say that? Because I've never known Ms. Vergils not to have her client's best interest at heart. Ever.
A lot of things she said.
A lot of things that she said you may have disagreed with, right?
Really all things.
Okay, all she said. Sometimes that's a lawyer's job. Sometimes they have to give their client the hard facts of what's going on. And they have to do that they have to give them their legal interpretation of what's going on, which may not suit with what you want to happen in the world. But they just give you a steady dose of reality. So if you disagree with her legal analysis, then fine, but show me your law degree.
This is classic Judge Simpson, direct, blunt, and surgically precise. When he asks for a law degree, he's not mocking the defendant. He's drawing a bright line between opinion and expertise. Courts cannot operate on "I feel like" arguments. Legal analysis comes from training, experience, and case law, not gut instinct or internet research. Mr. Gatlin believes his rights were being waived improperly, particularly referencing timelines like the 21-day preliminary exam window and the 180-day rule. But the transcript shows his attorney actually did the opposite. She communicated his refusal to waive those rights. That's critical. It undercuts the defendant's entire complaint. Judge Simpson catches that immediately. This moment also highlights something important for viewers. Judges are not neutral referees when misinformation enters the courtroom. They actively correct it. The court's responsibility is to maintain legal accuracy, even if that correction embarrasses or frustrates a defendant. There's also a power dynamic at play. The judge reasserts authority without yelling. He doesn't need to. The law is on his side, and once that happens, the defendant's argument collapses quickly.
No, I'm disagreeing with her legal advice.
Okay. And you're doing that with your legal degree that you have, right?
No, she was.
Yeah, that's what I thought.
No, I don't have a legal degree, but she was trying to get me to waive things. And like I was telling her, it would kind of waive my rights to 180 days into trial, right?
She just got before me. Did you even listen to what she said? She has indicated that you don't want to waive any statutory period. So she listened to what you said. She told me that, and I was going to set these for exam. Anything else?
Yeah, I don't want her on my case.
Well, she's on your case.
Your Honor, I would ask to also address bond if possible.
Yes, you may. Hang on a second. Let me set the exams in these cases. And which case don't you have discovery on that he's trying to set it before you guys get a chance to even look at it? That makes so much sense, but go ahead.
We're using media discovery on 25 FB 1090.
On 1090?
Yes, Your Honor.
All right. Discovery on that one is not complete. I'm going to note that. Do people have their witnesses available on the 3rd? Pardon? All right. Preliminary examination in these matters will be set June 3rd, 2025. 9 a.m. That's before me.
With that ruling, the court decisively moves the case forward. Preliminary exams are not optional checkpoints. They're constitutional safeguards designed to determine whether probable cause exists. By setting the exam despite incomplete discovery in one case, Judge Simpson balances two competing interests: the defendant's right to a timely exam and the prosecution's readiness. Notice what doesn't happen here. The judge does not punish the defendant for being difficult. He doesn't delay out of frustration. He simply applies the law. That's important. Many viewers assume judges react emotionally to defiance. In reality, experienced judges compartmentalize. Procedure comes first. Also pay attention to how this undercuts the defendant's earlier complaints. The very thing Mr. Gatlin said his lawyer was trying to waive, timelines, is now being protected by the court. That's a quiet but powerful moment.
Those both come before me. They're in person. As to bond.
Your Honor, we're asking the court to consider lowering the bond on case 25 FB 1142. Currently, it's set at $50,000. He's asking you to lower it to the same amount as his other case, 10%. Mr. Gatlin is an Ypsilanti resident. He is employed as a plumber. He at least was before he was in custody and plans to go back to that work. He's involved with his church. He plans to abide by his bond conditions. At this time, he's been in custody for 11 days now, and he is being held until May 29th on a case with Judge Washington. His sentencing is May 29th on that case. So he hopes that the bond will change at that time and that he'll be able to be released. So we're asking you to lower to something he'll be able to pay.
So he's being held on a case before Judge Washington now.
Until May 29th.
What's the proceeding on May 29th? Do we know?
Sentencing.
Sentencing. What kind of case is that? Do we know?
I don't know, Your Honor.
All right. Response from the people.
Your Honor, we've asked the bond to stay the same. We think it's appropriate. He does have multiple pending cases at the same time. The case in 1090 is a sole case. This case has concerning elements of that. He's accused of child abuse, but also fleeing police and possessing a firearm. We believe he's both a danger and a flight risk, and we think that this bond is appropriate.
All right. In this case, what I'm going to do is I'm going to deny the request for a bond reduction in this case and leave his bond in place. If something happens on the 29th, before your, because that'll be about 4 days before you see me. If something happens on the 29th where he's eligible for release, then you can contact my office and I'll reconsider this decision.
Thank you, Your Honor.
Thank you. Jerome Burns. Well, he's in back, right? So we might have to wait. Oh, no, there he is.
And
and Assistant Public Defender, not to carry out the ruling, Your Honor, on behalf of Mr. Richard Burns. Mr. Burns, say your name for the record, please.
Jerome Robert Burns.
The people's motion, this was discussed this morning regarding access to the premises.
This second case marks a tonal shift from criminal procedure into deeply human territory. We're no longer talking about timelines and bonds. We're talking about housing, domestic violence dynamics, and a child with serious medical needs. The legal complexity here is layered: lease ownership versus residency, victim rights versus property rights, and criminal court versus family law overlap. Judge Simpson immediately identifies a dangerous precedent. If victims can't return to their homes simply because they're not on the lease, abusers gain indirect power. That recognition is critical. Courts are increasingly aware that control doesn't always look like physical force. Sometimes it looks like keys, locks, and paperwork. This case forces the court to balance legal technicalities against practical harm. And throughout this exchange, the judge consistently centers the victim and the child, not ownership documents.
Yes, Your Honor, I did send that motion to the court and the counsel. Since then, counsel and I have been speaking. It's my understanding that the apartment is actually leased to defendant's father and I believe his mother potentially. I don't believe the victim is on that lease, even though that was her home and that was her residence. I wanted to forward that information to the court. I don't believe that we are in a position where we can ask, for her to be able to stay in that residence since she's not on the lease and it is the defendant's father who is.
Well, I think we're absolutely in that position. I mean, that would occur, that occurs all the time.
Well,
And the problem that I have with not being able to do it, or at least forcing it to happen, is that you would have individuals that may be potentially victims of, in a domestic violence situation, where the lease premises, which is their home, is leased to somebody else. And then they can't go back there. And they didn't do anything to be sort of on the outs.
Judge, if I may, I think there's a little bit more information that the court should have.
Okay.
My understanding, my client's father is here present, and he was the one that was able to update us on what was happening. The apartment is leased to him and his wife. That has been their home for the past 9 years.
Who's home?
Father and mother, not defendant and complaining witness.
Okay.
Yes, so it's leased to them, but that's their home. And my client and his wife were living with them at the time. They still live in the home currently.
Okay.
And my understanding as well, and it states it in the report, before this incident even occurred, the complaining witness had left the home. She had already moved out of the home. I know that the original allegation or issue was that there was the locks in the home were changed.
Yes, that's what I heard.
That is correct.
Why I set the hearing.
I spoke with Dad about that, and Dad said, yes, I did change the locks because she had since moved out the home probably about a month before then. And later he found out that the complaining witness was entering the home with the keys that she did have while he wasn't home, moving things around. And he stated that he felt it was necessary to change the locks because she was no longer living there.
Your Honor, my understanding is that the victim left because of the physical abuse and fear by the defendant. So she left and sought a safe place for her and the child. So that part's true. My understanding is the same, that she left, however, under those conditions, and I think that is an important addition. But going back to why I don't believe we cannot exclude defendant's father from a place where he's leasing, of course. So in regards to that matter, we'll just ask for there to be a civil standby so she still has belongings there. I of course ask that none of her belongings be touched by the defendant's family and that they cooperate with law enforcement to allow her to come and retrieve those. There's also a matter of the vehicle. So at this point, the concern I have for this victim, and more so for the child, quite frank, is that this child has very serious medical needs. This sexual assault took place at Mott's Children's Hospital while their child was in the hospital, defendant sexually assaulted the victim. This victim is in fear of the defendant. She, as far as I know, does not have a home to go to. She, as far as I know, does not have a vehicle for transportation.
This is one of the most emotionally charged segments of the entire hearing. The prosecution reframes the issue entirely. Transportation isn't convenience, it's survival. A sick child without reliable transport is a crisis, not a logistical debate. The defense response focuses on liability, insurance, and vehicle condition, legally relevant concerns, but emotionally hollow in contrast. Judge Simpson sees through that immediately. His frustration isn't with legal arguments, it's with the moral disconnect. This is where courtroom authority becomes moral authority. The judge isn't deciding ownership, he's deciding access. And he makes it clear that grown adults don't get to weaponize technicalities against vulnerable people. Audience reflection. When safety and control intersect, should courts err on the side of autonomy, even if risks exist?
And we're not just talking about going to get groceries. She has a child who has serious medical needs. And so it's concerning to me that she's not able to take that child where that child needs to go for medical needs and other basic necessities. So she's, of course, in a very, very bad situation. The two of them are married. There is a car that is, from what I understand, just sitting there, and there are car keys that go to that car. Counsel and I have been speaking throughout the day, and I thought we had an agreement that the victim could use the car since it's just sitting there and she desperately needs it for they have in common to be able to do what she needs to do for that child. Since then, I learned that the defendant is not agreeing to that. My understanding is that he has some concerns about the condition of the car. And I'll let Ms. Acuri speak to that. But again, my more immediate concern is this child right now. I'm not suggesting we should talk about the ownership of the car, but I don't understand why this victim cannot have access to their joint car to transport the child if she needs to.
And Your Honor, I did have an opportunity to speak with my client. Initially, the client's father, again, was the one who was able to facilitate. He did inform me where the vehicle is, that there are keys to the vehicle. And speaking, he doesn't have permission to give them over, obviously. I spoke with my client. He reports that there is front end, it's not damage, but there are front end issues with the vehicle. It's a work truck. It's a very large truck. It's a Chevy equivalent to, I think, a Ford 350. It doesn't have any of the additional enhancements, but he said it's a very large truck. All of his work stuff is in there. He's concerned.
His work, dad's or?
My client, Your Honor. This is his vehicle. He reports that this vehicle was his prior to. He does not feel that it's
prior
safe.
To
Marriage, I apologize, because the people indicated that this is like joint marital property or something to that effect. But this is a work van or truck that he has been using for his construction business. I do not think when she left the home, she left without the truck, Judge. The truck has only become an issue now. And I don't really understand how, if there is an emergency, the truck would really be of any help, because I think 911 would be the more plausible way to go if there's a medical emergency with the sick child. Back to the truck though, Judge. The truck, we don't know.
I guess I don't get this. I mean, I'll let you finish.
Sure.
But these are two people, married and or not married, who have a child together.
Correct.
That has special needs and may require medical care.
Mm-hmm.
For whatever reason, the big people don't get along now. And what I'm hearing you say is that as a father, I'm not going to make sure that the other caregiver of this child at least has some ability to get the child where it needs to go. That's what I'm hearing you say.
Judge Simpson distills the defense argument down to its core and exposes how it sounds. This is a rhetorical technique judges use deliberately. By repeating the logic in plain language, he forces counsel to confront the implication that a parent would deny transportation to the other caregiver of a medically fragile child. Once framed that way, the argument collapses. The judge doesn't accuse, he reflects, and that reflection carries weight. This is courtroom accountability without theatrics. This moment reinforces why judicial discretion matters. Statutes don't cover every human scenario. Judges fill those gaps with reason, experience, and empathy.
That's not necessarily what we're saying, Judge. I think that my client, again, with the mechanical issues with the vehicle, he indicated that it's not safe for her to drive. So it's not the safest vehicle to turn to if you needed anything in regards to transportation. And also, if he was in the process of getting the condition or the issue of the car fixed, and he hasn't been able to do that. So it's possible that driving it any further would possibly make it, put the car in a worse condition mechanically. What else did you?
So, Your Honor, if I may.
Yeah.
I'm not here to argue the condition of the car, just I understand this is all coming to the defendant. Again, and I want to be very clear that the victim has not asked for access to the car. I reviewed the case. I found that she does not have any transportation. And based on my experience, that is concerning to me when there is a sick child. How that car may be affected, potentially or not, by her driving it to provide for this sick child doesn't really matter. That is not what matters here today. This is an urgent situation. It's bad enough that she is homeless because of the physical assault she endured while having a sick child, The least we can do is give her access to the car for those purposes, and then they can work it out later. I'm not worried about whatever's going on between the two of them. She needs to be able to have some transportation. She has a small child that is sick, and she needs some help.
And Your Honor, my client, he did raise his hand. He just wants the court to understand that he's not trying to keep the vehicle from them. He says it's not a safe car to drive at all. That normally when the child has appointments, the state provides transportation for the child to get to and from his appointments. He has indicated to me that he has transported the child in their vehicle previously, but the wife does not normally drive that vehicle. It's not a vehicle that she's used to driving. She doesn't drive it normally. It's his work truck. And aside from.
So she's incapable of handling what would be.
No, I don't know.
50?
I don't know if she's licensed. I don't know if she's insured on that vehicle. I don't know. She's not. They're just.
Not insured?
She's not insured on the vehicle, Judge, according to what my client just told me.
How does that happen?
It's a joint insurance. So if I would have added her to the insurance, then she'd be able to legally drive that vehicle. If she's not added to the insurance, she legally cannot drive that vehicle.
No, that's not what he's asking you. Why did he?
Your wife?
Do it.
Why did he?
Really?
Her in the vehicle?
And it cost way too much money having her insured on that vehicle.
And that's my understanding, Your Honor.
Was there a vehicle she was insured on?
When her dad had a vehicle for her, she was insured on that and had received a.
Where's that vehicle then?
That was 7 years ago, sir.
And that's
so for 7 years she hasn't been able to drive.
She's able to drive. She just hasn't. She chose not to.
And that's kind of what Dad told me, Your Honor. Dad just says he doesn't really know her to drive. She's not one that drives normally. She's usually at the house, or they use the transportation provided by the state whenever they needed to take the child to the vehicle. Other than that, my client was the one who would do the majority of the driving.
Your Honor, what we're seeing, I'm sorry, this is a perfect example of the worst domestic violence dynamic you could possibly imagine. The fact that the defendant and the defendant's father are deciding whether or not this victim can drive a vehicle, when she can drive, how can she, I mean, this is.
I don't think that that's what we're saying, Judge. We're just stating facts that he stated that she had a vehicle at one point. She no longer has a vehicle. If she doesn't have a job to go to and she doesn't have any other need to drive, all we're stating is that she does not drive normally. The bottom line on our position, Your Honor, is my client indicates that the vehicle is not safe. Now we've concluded from him that she's not insured on the vehicle. I don't know the status of her driver's license. So honestly, I think that this is a family law issue. I don't think that this pertains to our case at all. She left the home previously before this case happened.
I want the keys turned over.
You want the keys? No worries, Your Honor.
I want her given access to the truck. She can then make, I'm assuming she's a grown woman, so she can make her own decision as to whether or not she wishes to drive that truck.
Okay.
She can also make her own inquiries as to the insurance that's available on that truck. And the like. She can even take it to a mechanic and have them look at it as to its roadworthiness. But geez, she's grown and she can make her own decisions and doesn't have to have defendant dad make those decisions for her.
This is the turning point. The court restores agency to the victim, not by declaring ownership, but by granting access. Judge Simpson cuts through months of potential manipulation in a single ruling. Keys will be transferred. Decisions will belong to the person who needs them most. The logistical solution, public defender to prosecutor to victim, is simple, but the impact is enormous. It removes control from intermediaries and restores dignity. This is a textbook example of how criminal courts can intervene in domestic power imbalances without overstepping into family law adjudication.
So how are we going to get these keys to her?
Dad says he has the keys. It's not with him right now, but I mean, previously, again,
Them to the public defender's office can get them to the prosecutor's office can get them to the victim. All right. What do we then need to do on this case?
so Your Honor, initially we were asking for the adjournment. There was a little bit more discovery or investigation, I would say, on our end that we needed to complete before we decided which way to go.
About the 5th or the 12th, counsel?
I didn't hear you, Your Honor.
5th or the 12th?
Let's do the
He's in custody, that's why I'm asking.
Let's do the 5th, Judge. That's fine.
June 5th, 2025. 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Judge.
This hearing showcased two very different courtroom battles, both unified by one theme: control. In the first case, the court reaffirmed that legal strategy is driven by law, not emotion. In the second, it rejected the misuse of technicalities to maintain power over a vulnerable victim and child. Judge Simpson ruled with consistency, clarity, and purpose, protecting procedure in one case and humanity in the other. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.